Hello and welcome everyone to the Kelleher and Holland webinar series, Your Legal Compass, focusing specifically on estate planning, trust administration, and elder law topics. Today we are talking about common estate planning myths and misconceptions. Our goal is to help you navigate a clear path through the confusion to understand what truly protects your wishes. We encourage you to ask any questions using the Q&A button in the Zoom control panel. And depending on time, we'll try to answer them live at the end of the presentation, or we will follow up with you via email directly afterwards. So setting the course for the discussion today is Don Sadowski, a seasoned attorney with more than 30 years of experience integrating estate planning, taxation, and business law to help clients protect and transfer their wealth. Don brings a practical, holistic approach to planning, advising individuals, families, and business owners on strategies that support both their financial goals and long-term legacy. So, Don, I will turn it over to you to get us started.
All right, thank you. Welcome in, everyone. So as Amy stated, we're going to cover common myths and misconceptions related to the laws governing the disposition of your property when you're either incapacitated or you're not here. Now, the list we're going to cover today, we have a half hour. The list is not all inclusive. There are many, many misconceptions out there, but the list I compiled for today's webinar is really representative of the statements that are most frequently made to me by clients and members of their family over many, many years of practice. But before we get started, I just want to tell you, estate planning is more than wills and trusts. If I were to ask you, most people would say estate planning is about a will, about a trust. It's really more than that. And it's about making life as easy as possible for your loved ones when you're not here or you're incapacitated. So if I were to ask the people today, if I were to ask you right now, if you died, what directions would you have with respect to your assets? And I think probably most of you would say, I have some general idea and give me some direction and say, yeah, I'd like this asset to go to this person. I'd like this asset to go to this person. Maybe this person would be a beneficiary on my life policy or on my retirement plan. And if I told you, so you'd have a general idea what you would want to have happen. But if you're like most Americans, your wishes are not going to be followed. And then you say, Don, how the heck is that? Because according to the most recent study that's been conducted, 68% to 76% of Americans don't have a will. So if you lack a will, state of Illinois, if you live in Illinois, writes a will for you. And I think maybe some of you already know that, but the point of the matter is it doesn't matter what you want or what you want to have happen. If you don't have it written down, very simply, it includes that information, it's not going to occur. So the first misconception we're going to talk about relates to the idea that your specific directions don't necessarily align with the state's law. And the first misconception is believing if you were to die without a will and leave behind a spouse and children, that your spouse would automatically inherit all your assets. It's not true. The state law says in that case, if you have children, 50% go to the kids, 50% goes to the spouse. A couple of years ago, I had a decedent, a 50-year-old, had a heart attack, no will, with about a $3 million estate, and the wife was, in the meeting when she found out with her kids that she was not getting the entire estate, it was a really rough day for her. And we had to try to figure a way to get some of the assets over to her. But the problem is she had a couple of kids who were under age 18, and so we were stuck with a court supervised guardianship. We couldn't have the minor disclaim assets so that they would go to the spouse. Second misconception, if you were to die, and I get this all the time, people who are not married say, Don, I got to do a will. And I say, why? Well, I don't want my assets going to the state of Illinois. Well, it's not true. People confuse property that's unclaimed Unclaimed property can go to the state of Illinois, but when you die, the property will go to someone, maybe a remote uncle, it could be a second or third cousin, but if you die without a will and you're unmarried, then 50% go to your parents, which is not typically what happens. You don't upstream assets to parents. And the other 50% go to your brothers and sisters. And some of you would be like, boy, I would never consider, leaving any property to my brother or my sister. But third misconception of revocable trust will protect the residents from long-term care. This is generally the parent will say to their child, I have a trust, son or daughter, and this trust is going to protect the house if I ever have to go into a nursing home. If that ever happens, you might want to take a look at the trust. Only certain types of trust will exempt the asset, the house, for purposes of determining your eligibility to get a government program like a Medicaid payout. Revocable trust, your garden variety revocable trust doesn't work. Why? Because the person who created the trust retained powers over the trust's assets that are tantamount to complete ownership of the asset. In their certain types of irrevocable trust would qualify and would actually immunize the asset from eligibility. Fourth, believing wills avoid probate. I hear this all the time. Don, I have a will, I don't have to worry about probate. Well, let me tell you that in general, if you have a will, you guarantee probate. Why? Because when you die, your will, the words on the page don't come alive until the court admits it to probate. So we have to petition the court. The judge will look at the will to see if it meets the requirements of a valid will. When they admit it to probate, now the words on the page come alive and the will now speaks for you, but it doesn't avoid probate. The fifth, believing a trust avoids estate tax. Trusts avoid probate. Wills avoid intestacy laws applying to distribution of your assets, but a trust, the assets that you put into a revocable trust are considered yours for estate tax purposes. Again, why? Because a revocable trust usually, in the revocable trust, usually you retain the right to revoke, you retain the right to change the trust, you retain the right to all the income, all the principal. And so the tax regulations say that if you have all these rights, it's as if you own it. So people, again, confused that they don't think they're going to pay estate tax because their assets are in a revocable trust. Believing a will controls the disposition of your estate. This must come up like every week in my meetings with clients. So they fill out a questionnaire, they send in maybe their current trust document. I ask them to provide their assets. And one of the things I do for the meeting is to do a day in the life. What would happen is if you died, or this person died first, this person died second. And when I tell them, I said, guess what? Your estate plan document doesn't speak to 85% of your assets. And they're like, what do you mean? I've got this will. It says it goes to John, it goes to Mary. And when I tell them, because your will only speaks to assets that are in your name alone and assets which do not have a beneficiary designation. So when you meet with your financial planner or you go to HR at work and you fill out your 401k paperwork and you put a beneficiary in there and you put in somebody's name. Then you go and you do a will and you leave the assets in your will to certain parties. Well, the assets that don't have the beneficiary designation, they'll be controlled by the will after the judge admits it to probate. And the asset that you directed be paid per a contract that you made with the custodian is going to be honored by the custodian, and it's going to go to the designated payee. life insurance contracts, annuities, life insurance, retirement accounts. Those are generally those are generally paid out based on contract or provisions that direct. Transfer on death is another a way of designating, say, a bank account to go to a third party, and the will does not speak to these things. So sometimes it makes, if you do planning, you have to coordinate your titling, you have to coordinate the ownership of the asset with the written documents so that they're linked properly and that the definitive document will speak as to the disposition of your assets consistent with your wishes. Next, believing you don't need a will. So this is less frequently, but there was a time when dad would die, mom would grab the oldest kid, run to the bank, and say, "Come on with me to the bank." And they go there, and the mom puts the oldest kid on all the accounts. And in the course of dealing with that client, I might say, "Hey, when are we going to do your estate plan?" They say, "Don, I don't have to worry about it. Everything's in joint tenancy. And my family knows exactly what I want. This is all family. They all get along. And this is what I want." Well, I'm here to tell you that in Illinois, we have a presumption that if you put somebody on as a joint tenant, the presumption is you intended to make a gift to that person. And legally, that person who receives that asset, if they survive the decedent, doesn't have to share that with anyone. And maybe they will, more times than not, they do. But what I'm going to tell you, if you take nothing else away from this, joint tenancies are inexpensive, they're easy to do, but they can result in a lot of unintended consequences. I will meet with families all the time who a parent died, and they want to know why they're not getting something under the will. The will says I get 25%. I said, well, because your mother put your sister or your brother on this account, and now there's tension in the family. Are you going to share that? What are you going to do? And all of a sudden, the kid may have amnesia. Well, mom wanted me to have the asset. And I will tell you, that's one of the biggest areas where the family ends up having major disagreements. But more importantly, it's important for the person. So we're talking about your estate, your assets. It's important for you to understand what a catastrophe joint tenancy can be. And I'm going to give you some examples of clients who had joint tenancy that happened over the years. So I had a client put an account, substantial amount of money with their kid as a joint tenant. That kid suffered a financial reversal, had to declare bankruptcy, and the bankruptcy court ordered the asset to be liquidated, and 50% of the proceeds went into the bankruptcy estate of that kid. And the mother lost control of that money. I had another client who had joint tenancy with a child, and the child was involved in a lawsuit. Child had a judgment. The party that prevailed went ahead and started supplementary proceedings to enforce collection. And through the process, the joint tenancy property turned up in a citation proceeding, and the court ordered that the property be sold and 50% go to pay this creditor. I have had a number of cases over the years where the joint tenant, the child joint tenant, decides they don't want to share the asset. And I know that my client didn't want that, but the client, for whatever reason, never either updated their plan, didn't advise, and the kid ended up keeping the money. And clearly it was an unintended result. And finally, I will tell you a couple of instances where the joint tenant, one was in a car accident and became incapacitated. The other one had I don't know if it was a stroke, but there were guardianship proceedings. initiated, and the probate court ordered the property to be sold and 50% to go into their guardianship. So I'm a big one on control. Joint tenancy, again, is easy, quick, cheap to do, but it's not perfect for every asset and it's not perfect in every situation. There are some exceptions. There's some ways to coordinate it with your will so that the family has a leg to stand on, that the joint tenancy wasn't intended to make a gift, and that the executor can make a claim to the money. But don't think that joint tenancy is the answer to a quick and simple estate plan. Believing asset protection, we're on the next one, giving your assets directly to your kid. Well, we talked about the problems of joint ownership. Um, one of the rules in my practice is to try to avoid joint relationships as much as possible because you don't have control. But if you give your assets to your kids, especially if there is a threat out there, we have laws that basically say if you try to transfer assets and in the result you render yourself insolvent, you could be facing some kind of fraudulent conveyance charge and they can unwind the transfer. But I do have some clients who the water's calm and they'll put a kid or somebody on their account, thinking that, well, maybe there might be some issue down the road. You don't you don't protect that asset because again, something can happen beyond your control to that joint tenant, and and you're putting your hard-earned money at risk. Believing life insurance proceeds aren't subject to estate tax very quickly. People are surprised when I tell them that if you're preferred health rated, you're 50 years old. You can get a $2 million policy today for about $1,500 a year in premium. Sounds like a pretty good deal. And it is. It's very cheap. You can buy that policy for $1,500. You can contract COVID and die a week later, and you have a $2 million estate, a taxable $2 million estate, subject to tax. People say, well, how can that be? It's because under the regulations, at the nanosecond of your passing, the government says you had control of this agreement with a death benefit of $2 million, and it's subject to tax. And I bring this to your attention only because some people will say, well, I'm way below the exemption. We have a $4 million exemption in Illinois. And they say, well, my IRA, equity in my house, portfolio, and all that is about $1.5 million. They don't count. They don't count the insurance. And not many people have $2-3 million of insurance, but some people who are in the asset accumulation phase, their late 30s to maybe 50, they buy large policies, and that policy puts that client potentially at the tipping point where there's some estate tax. Insurance is excluded from income tax, but not estate tax. So that's the myth there. People believing planning is only for the elderly or people of wealth. All right, now think about what we talked about. Dying is not a discriminatory thing. We could die at any time. You could be any age. Read the paper, see what's on the internet. Dying is every day, it's a possibility. And it doesn't discriminate. You could have 100,000 in assets, you can have $1 million in assets. So when people say, I really don't need to do estate planning, I'm not a millionaire, I'm not this, I'm not that. Whatever is worth striving for during your life is worth protecting when you die. And if you don't believe it, that's fine. But most people work very hard to accumulate what they have. The question is, will they take the time to make sure it's protected and it gets to the people when they want and the amounts they want and to whom they want it to go to. So you can really just dispel that notion here. You're preparing for incapacitation, and you're passing. And then the last one, believing estate planning is just about death and taxes. Well, it really is more than that. It's about making sure that you have the right people in the right place to take care of you if you're incapacitated, to make healthcare decisions for you in the event, informed consent, death delaying issues, medical health related, medication programs, dealing with Medicare. Um, it's also about who's going to run the show if you did pass away. You have the right to pick who you prefer to be in charge, whether it's a trustee or as an executor. Guardian. When was the last time you thought about, boy, if I died, who do I want my kids to live with? Where do I want my kids to live? Do I want them living in my house, the house that they were raised in? Do they want them living with the guardian? Do I want spouses to, does the person, have to have a spouse? Because I want spousal family to raise my kids. What kind of education do I want for my kids? If I'm not here, are they going to carry out, who's going to raise my kids in the manner that's close to my beliefs? People just don't think about that. In the rush to get things done on a day-to-day basis, it's hard to think about those things, but intelligent plans address those types of topics. Um, how many of you have what we call a standby guardian designation? What's that? Well, if you have a spouse, you go out to dinner some Friday night, and let's say you're in a fatal accident. Do you know who's going to have custody of your kids? If you have a will and you designate a will, I can tell you in Cook and Lake County and DuPage and even McHenry, the judge is going to probably go along with whoever you designated in your will. That's good because it's going to the person that you choose. If you don't have a designation in your will, guess what? The judge is now going to decide who is best, or who's the best person looking at it from the child's interest. Usually is going to be a close family member. Um, but if you don't have a will and you don't have a designation, chances are your kids will go into protective services, even for a few days, possibly with a foster care home, until an emergency hearing can be had, and a temporary guardian is appointed. And then when it comes to the permanent guardian, the statute says any interested person can petition to be the child's guardian. So you could be having people that you would never, ever consider eligible or good nominees for your kids. And it's going to come down to, if the child's under a certain age, I mean, the judge will interview the child, but more times than not, unless they're 12, 13 years of age where they can articulate really their preference, it's going to go to who the judge decides. As I mentioned to you earlier, estate planning is making life as easy as possible for the loved ones. I see a lot of infighting because the person doesn't have the plan. People with businesses, the owner will tell me, Don, it's family. What are they, everybody's on board and it's going to go a certain way. And then it doesn't. Everyone will think dad wanted this, mom wanted that, he didn't want that, she was supposed to do this. And they spend more time arguing over what's to happen. And it's generally not a good situation. But when you do a plan, you can take charge, pick who your executor is going to be, pick who your guardian is, pick who's supposed to be your, pick a party if you want to just make sure that things are done correctly. There's different roles and designations out there today to build a lot of flexibility into your arrangements, and where you can avoid a lot of argument in the family. And that's, you don't want, here's what I will counter every now and then, where the brother or sister picks up the deceased brother or sister's affairs and is spending months unraveling what the heck was going on in this person's lifetime. And as opposed to having things organized in a manner where the kids have or whoever's in charge has an idea what you own, who's entitled to it. And when plans are done properly, it really is something. You can meet with the family for a few hours, you give them rules of the road, they leave, you supervise them from time to time, you answer questions, but by and large, it gets done quick, painless, and the kids, unfortunately, you're not here, but the kids just say over and over, thanks, mom and dad, thank you, thank you, thank you, because they took the steps to organize their affairs and make life as easy as possible for them. Um, so there was a question that went into the portal before the meeting, before the webinar, and I'm going to try to address it. I'm happy to send an email to this person, but there was a question that was asked about someone had died and they had a trust, but not all their assets went into the trust, and was wondering, can I get them into the trust now? So the answer to the question is it's not as so what happened was the assets went to the joint tenant, the surviving joint tenant, but the surviving joint tenant doesn't necessarily want those assets and wants to fulfill the decedent's wishes. So in that case, depending on the asset, there is a way for the joint tenant to legally refuse the asset, and then you would look at the will, and if the person has what we call a pour over will, the asset would then pass through the will, and in the will, it probably leaves any assets that are not in the trust when the person passes to pour into the trust. Thereby, the asset then becomes an asset of the trust estate. That's one option. Unfortunately, if the joint tenant accepted the property, then it's a little more entangled. But there could be a workaround. Um, and the second part of that same question was, are there assets that I could put into this person's trust? The answer to that question, assets that can go into this person's trust that are not the decedent's joint tenancy assets, the answer to that question is a little more complicated. It would depend on the reading of the trust, but um, I'm not going to say categorically that a non-grantor, so the person who didn't create the trust, doesn't mean that the trust is exclusive for asset transfers, property owned by the person who created the trust. There can be assets transferred by others, third parties going into that trust. But it probably would require a reading. It's really more taxes than anything else. It's more of a tax issue than it is an issue of, can I make a gift to this person's trust? Because in this particular case, the person making the transfers to the trust might be even a beneficiary of the trust. And so you have to get into some of the more technical aspects of what are we really doing here when we convey assets to a trust of which I'm already a beneficiary. So, and if there are any other questions in the queue, I'm happy to take them.
Thank you, Don. We are just about
Yeah.
out of time here, so
Okay.
thank you for joining us today, audience. We hope that you found Don's information that was presented today helpful. Please feel free to contact him directly for further guidance, and I have his contact information on the screen for you. And watch your inbox and our social media pages for details on our next webinar in this series. Or if there is something you would like to know more about, please drop us a line at attorneys@kelleherholland.com. Thank you. Bye for now.
Thank you.